All right, welcome to Module 7. This week we're going to examine police use of force, what the legal requirements are, how it's reported, and who investigates. So as we look into the module here, the first thing we're going to talk about is the legal requirements for when officers can use force. Then we'll do a deeper dive into what use of force levels are, different variations of the type of force that can be used and when. Who investigates the force, again, depending on what level of force is used. If it's lethal force, there's a different entity that has to investigate that here in Washington State. And then what are the general reporting mechanisms for uses of force? So as we look to anything legal, then we're looking for laws, which would be found in the Revised Code of Washington, the RCWs, and we'll go into the exact RCWs here in the next couple of slides. But in a nutshell, this slide captures the opportunities where force can be used legally. That is to prevent escape. You can involuntarily commit somebody for treatment, and typically, if it's involuntary committal, there's a likelihood that that person would be combative in getting that treatment. So force would have to be used to overcome the resistance. Protective custody to execute a search warrant. If there's an imminent threat on the officer or on any other population of the community, then force can be used to stop the threat and then to execute court orders. And then the most commonly used type of force is to effect an arrest. So when we talk about the RCW that describes these permissible uses of force, that can be found in RCW 10-120-020, and you can see here in a little bit more detail what was basically outlined in the previous slide. The execution of search warrants, take a minor in for protective custody, evaluation of treatment, goes into a little bit more detail on what each one of those looks like. Then RCW 9A16020 also provides when a use of force is lawful. It goes into a little bit more detail for the performance of the legal duty of the officer. Those two RCWs together kind of provide the overall framework from which use of force, at least in Washington State, is determined whether it's legally justified or not. So we also find in statute a requirement that force, when it's used, it has to be necessary. And this is an important distinction. And so we look at the definition in statute for what necessary means. It means that no reasonably effective alternative existed, and that the amount of force that was used was reasonable to effect that lawful purpose intended. So then it also defines deadly force, which is the intentional application of force through the use of firearms or any other means reasonably likely to cause death or serious injury. So when we review uses of force, especially uses of deadly force, these are important definitions to remember: is the reasonably and necessary, so that there was no other alternative that was reasonable, and that the amount of force or the level of force was reasonable to effect whatever the lawful purpose was. So an additional kind of lens from which uses of force are evaluated is the Graham factors. And the Graham factors are taken from case law, which was the Graham versus Connor case. And in that case, which you'll read in this week's lesson, you'll come to understand how the case came about. But really, the strong takeaways from the Graham v. Connor case, which created the Graham factors, are really four prongs when you're looking at a use of force. What was the need for the application of force? That goes into what we were just talking about, was it necessary? Then number two, the relationship between the need and the amount of force that was used. That also goes back into this definition. Was the amount of force reasonable to the amount of resistance that existed? And was it reasonable the lay person that amount of force was justified to get to whatever the legal end was, to effect the arrest or to stop the threat or to get somebody into treatment. 3, the extent of the injury inflicted. And then lastly, whether the force was applied in good faith effort to maintain and restore discipline or maliciously and sadistically for the purposes of causing harm. So the fourth one really goes into what was the intent from the officer. Was it to do the legal function and restore discipline, or was it only for the purpose of causing harm or done maliciously? So when we are talking about reasonable and necessary, when we talk about the Graham factors, we can apply the Graham factors to really any use of force. And when we look at the photos that are on the slide here, what is reasonable? So on the left, we see what appears to be 2 females, and one is pulling a wallet out of her purse. So if you're applying the Graham factors, what's the severity of the crime? Let's say shoplifting or just petty theft. Relatively very low threshold for the crime. You're talking misdemeanors, depending on the value. Maybe it could get to a felony. But there's no life safety interests here. Nobody's going to be killed from this act. So what would be a reasonable amount of force or alternatives to using force in this situation? And then you compare that situation to what you presented in the photo on the right, where you have somebody pointing a firearm at you. What is a reasonable alternative to that? You're being presented a lethal threat. So the alternatives that would likely resolve that situation are going to be a lot fewer, and the timeliness of making that decision is much more imperative because your life safety risks are extremely high. So when you're looking at the reasonable alternatives, what exists, it's in the moment, looking at it and applying the Graham factors. So we'll take a look and you'll see a lot more information on the use of force continuum. And there's a video in the module. If you haven't seen it, it will begin with this slide and explain the use of force and the thought process of the force model. But on the left side, you have the subject actions. In the middle, you have officer perception. And then on the right side, you have the officer response. And this is really important to understand when we're looking at any type of use of force or a use of force situation. So at the bottom left, you have compliant for the subject action, resistance, which can be from passive to active. An example of passive resistance might be an officer tells somebody to get out of the car, they're under arrest, and they just sit there in the seat and refuse to move. Typically, you'll see this a lot in like protest activities. Maybe there's a whole group of people that are protesting outside of a building, and they're told they're under arrest and they need to stand up in order to be handcuffed and processed, and they refuse to do that. That would be an example of passive resistance. Active resistance would change. You can use the same principle. Let's say it's the same protest, but now the protesters have handcuffed themselves to a fence and are actively holding on to the fence, and they're not letting officers try to free the restraints in order to get them into custody. So they've taken it from just being passive and not being cooperative to now they're actively using force or some mechanism to resist that arrest. So that's the difference there in the resistance. Assaultive is now, let's use the same example of the protest. They actively chain themselves to the fence, and when the officer gets there with, let's say, bolt cutters to cut away the restraint, the protester then punches or is pushing away the officer. Now you have assaultive behavior where there's a physical potential for injury to the officer or to other people. And then that can go up even to a higher level if the assaultive behavior is serious and it's likely to be, fatal. So based on if now that same protester produces a knife or they produce a deadly weapon. They grab a rock and they're hitting an officer on the head with a rock, or they're going to throw a brick or something like that. Now the likelihood of serious injury goes up. And so what you have in the middle of the diagram here is the officer's perception. And so you have delays from when something happens. So you have to see it, perceive it, and then react to it. So the perception is the ability for the officer to understand, process, and the opportunity to react to what is happening. On the right side, you have the officer's response. So based on the subject's actions, the officer's perceptions of what those actions are, then they're going to create a response. And you have cooperative controls, which would be something like giving verbal commands. Hey, stop, you're under arrest, you can't protest here, you can't block the roadway, you need to leave. Those are cooperative controls. A compliant person with a cooperative control is going to listen to the command and then abide by that. You have contact controls. That would be something where you go back to that passive resistance where the protester just sitting there, they won't do anything. The officer comes up, places the handcuffs on them, stands them up, and now the person is responsive to those types of controls, the grabbing of the hand or the arm bar to control the person and stand them up, and the arrest goes without any further incident. As you continue to escalate up that, you have some counter techniques or defensive tactics, control tactics, where now the officer's having to deploy either like physical strikes, they might have to like hit them or twist their arm and apply pain compliance. Or as you go further to defense tactics, maybe they have to use a chemical munition like OC-10, or pepper spray, a taser, an aspeton, any type of a tool or an implement to further attempt to get somebody to be cooperative is now escalating in what the officer's selection of that tool would be. And you can see that goes all the way up to that deadly force, which is typically a firearm of some sort, either a handgun or a rifle. So you can see this model does a pretty good job of presenting what the subject's actions are and then how the officer needs to respond. So take a look at what are some of the levels of force and some of the tools that are available to officers. So you have just the mere presence of an officer is considered to be a level of force. A uniformed officer, just being in uniform and being present somewhere is already commanding a presence, and they have legal authority to, within legal context, order people to do or not do things. So the first level, which is often overlooked, is just the officer presence. Then you have verbal commands, again, telling someone to do something or not do something is an example of a verbal command. Control tactics or tools, kind of a large variety of things that apply under that category. You'll see handcuffing is considered a use of force. A lot of departments will not consider it to be a reportable use of force unless there's some sort of an injury or complaint of injury that would result from the handcuffing. You have OC-10 or pepper spray. You have the collapsible baton, a taser or an electronic control weapon, as they're commonly referred to now. And then your deadly force category would be your firearms. And I kind of mentioned that, but it's important to understand what tools are available to officers and then where that falls on the force continuum and the officer's thought process. So here's taking what that first diagram looked like and then breaking it down in kind of a more palatable illustration. So compliant suspect actions should result in most cases with a mere officer presence or maybe verbal commands in order to effect an arrest or to control the situation. And you'll see these kind of stair step up and they're mirroring the suspect's actions with the officer's actions. So passive resistance typically will also be verbal commands. Active resistance, you're probably looking more towards that control tactics or defensive tactics. Different departments will refer to it slightly differently, but that's where you might have your taser, your OC-10, maybe some hand strikes, pain compliance tools are going to be employed more in that passive and active resistance areas. And then you get to that assaultive behavior. There's obviously a wide variety of what assaultive behavior can look like, and there's a variety of officer actions that can be done to combat assaultive behavior. But ultimately, if it's on the high spectrum of assaultive behavior, then the likelihood of deadly force tools to be employed are pretty high. So when we are looking at force, we also need to consider, the officers, when we looked at necessary and reasonable, was the force necessary? Well, in order for force to be necessary, there also has to be consideration of, is there any way to de-escalate whatever's happening so that they could avoid using a type of force to affect whatever the legal initiative or goal is. So when we look at de-escalation and force, there's really kind of three tactics or strategies. So utilizing time, utilizing distance, and utilizing shielding. That can mean a lot of different things. So time, distance, and shielding can mean trying to slow down the pace of the event. That could be just allowing for other things to occur. You can have maybe aid personnel show up if it's a medical situation where once aid is on scene, they bring with them a whole another tool set of things that maybe chemically could be introduced to help calm somebody down. Distance, time and distance together can help slow down the pace of an event. If you are only feet away from somebody who potentially, let's say, has a knife, you're at a much higher threshold than if you backed out to 50 or 100 feet away and could use maybe a bullhorn or a cell phone to call in and to try to negotiate somebody down. By creating further distance, you've already reduced the high threat threshold there. You haven't eliminated a threat potentially, but the threat towards officers can be greatly mitigated if you're able to present greater distance from whatever your subject is. Not always possible, but it is a good tactic that police can use. And then shielding really comes into in situations where maybe you don't have a ability for great distance, but what can we do to put something in between the suspect and the officer? That can be like physical shields, ballistic shields. That's one thing that obviously could be shielding, but also positioning a vehicle in between somebody, or like a fence or a porch or a guardrail. If you're inside, that might be a sofa or a desk or a table, but putting other objects between yourself can also afford a little bit of time and distance to have the officer react in a way that can lower the level of force necessary to overcome the resistance. So when we think about any use of force and de-escalation tactics, we should be also thinking about time, distance, and shielding. So de-escalation is a term that's used widely, and I think we need to define it a little bit as far as what do we mean by de-escalate and who chooses to de-escalate. So we can look in the graphic here, you've got a whole bunch of different people yelling, but who really is controlling an arrest situation? You might say, well, it's obviously the officers in control because they're the ones making the arrest. But as you look at the use of force continuum, really it's the suspect's actions or lack of actions or their response is what in most situations is going to drive the officer's response and the level of force that would be required. Obviously, there are situations that have been highly captured in the media and other places where an officer makes a grave decision to use a level of force that was not necessary or reasonable, and they escalate things themselves, and they fail to de-escalate or recognize what the situation actually is. But in most situations, outside of an officer making a bad call, the ability to de-escalate situations is going to be on the part of the subject to choose. Now, officers can, like I said, use tactics to create a situation where that's more likely to occur than others, using time, distance, and shielding, trying to slow down the event, actively listen to what the subject is actually saying and what their true concerns are, trying to negotiate when possible. Again, every situation is going to be unique, but if you are able to utilize time, distance, or shielding, and you are providing some avenues for the subject to make their own decisions to help make that outcome better, then you're preparing an environment where there is at least an opportunity for the subject to de-escalate themselves. So some considerations, is this something where the police could leave or create that distance? Is there an immediate public safety concern? Using the gram factors, what's the severity of the crime? Why are the police there in the beginning? Is this a barking dog complaint? Or did somebody just get murdered and there's other people potentially that could get hurt? Is this subject known to the police? If they left today, could they come back tomorrow when things are different and effect an arrest at a later time? Those are considerations and tactics that the police can use, again, to help de-escalate the situation and help the subject de-escalate themselves. So when we look at force, a police officer has a lot of considerations that they have to make before they select a tool to use or deploy any actual force. So we'll look at the screen here. Now in RCW statute, there's requirements for officers to consider a lot of these things before they use force and when they select which force they're going to use. But is the person they're going to arrest, are they visibly pregnant? Are they morbidly obese? Why would we consider those things if we're going to use force? Well, obviously, we would be concerned about the health of the baby if you're using force against a pregnant woman. If you have somebody who's morbidly obese, there's a lot of potential underlying health conditions that could be aggravated if, let's say, you used OC10 and obstructed their ability to breathe, or used a taser, or if you had a prolonged fight, their heart rate and ability to recover from a physically strenuous activity could be something that could create a lethal event. So it's something to be aware of. Also, you have somebody who's extremely strong, much stronger than the officer. That's a force consideration, because now their ability to overcome the officer's strength is of great concern. So they might have to pick a different type of tool that would be able to overcome their strength or ability to resist. How many subjects are you dealing with? You look at the lower left, you have a lot of individuals that are, flashing gang symbols and wearing gang paraphernalia. That would be of a huge consideration for force and the number of officers that you would need to safely effect an arrest. Known weapons or visible weapons or reported weapons, and then drug and alcohol abuse, as well as their mental state. If you are responding to a call for service and you know that your person that you're going to interact with has some mental health illnesses, that can dramatically impact their ability to perceive events and respond in what would be a rational or expected way. So all of these things the officer needs to be aware of and be thinking about before they ever get to a point where they're selecting a tool or a level of force to overcome resistance. So let's consider now somebody has used force. And for the illustration here, we're just going to call it Agency A. So Agency A uses force. We have to now determine who's going to investigate it. So was it a lethal use of force? If it's not a lethal use of force, then generally speaking in Washington State, Agency A is going to investigate their own force incident, because it was a low level of force. Nobody was seriously hurt or killed, and so their individual agency, usually a supervisor, will go to the scene and investigate that use of force. In Washington State in 2021, well, actually 2020, the law changed. In 2021, a new state agency was created, the Office of Independent Investigations. But for the last couple years, there's been requirements if lethal force is used that it has to be investigated by an outside entity meaning an agency, a law enforcement agency, not part of the agency that used force. And so those are referred to as independent investigation teams, which are IITs. And then now the Office of Independent Investigation, which is, like I said, a new state agency, is still being established and put together. They're still hiring investigators. So they're not able to respond to the scene today, but in the next year or two, they'll be fully staffed and able to respond and investigate these types of incidents. So this flow chart kind of shows if it was a lethal use of force by Agency A, then right now today, it would be investigated by independent investigation team, meaning outside law enforcement agencies that have no conflict of interest with the officer or the agency that used that force. So a use of force investigation by default is a criminal investigation if it resulted in death or serious or substantial bodily injury. So what that investigation looks like under the criminal prong is for criminal acts. Is there any evidence of excessive force or an unreasonable application of force? It's like I said, by default, it's a homicide investigation if somebody died as a result of the force. It's investigated externally from the agency. So again, the law changed a few years ago. WAC 139.12.030 created the requirements for IITs and the Office of Independent Investigation to do these independent investigations, with also adding a level of transparency requiring community members to be part of the investigation. So a minimum of 2 members of the community who have no affiliation with law enforcement. They get to review the entire case file. They're privileged information provided to them, and they get an advance copy of every media release that is presented. And a criminal investigation has to be separate from an administrative investigation. We'll get into that a little bit further. And the reason is for Garrity concerns, that if you had a statement under Garrity, that it would be a compelled statement. And a compelled statement can't be used in a criminal trial, but it can be used in an administrative trial. So it's important to understand the difference. So a criminal investigation would be something completed by an IIT or eventually the Office of Independent Investigations, the OII. Administrative investigations usually are conducted by the employing agency after the criminal investigation is completed. So the admin investigation is going to look at, was there any policy violations? Was there any training concerns? Were the things that they did consistent with how the department trains and teaches people to do things? They can, under an admin investigation, depending on the agency, compel statements, which is to force the employee to explain what they did and why they did it. And if they don't do those compelled statements, what would happen is they could potentially lose their job. So that's the compelled statement. The Garrity concern is if the employee feels like they don't answer the question, that their employment status is in question, that falls under the Garrity rights. And then Weingarten concerns or Weingarten rights is the ability to have union representation during questioning. So again, criminal administrative, they have to be separate investigations. There can't be any communication from the administrative investigators to the criminal. Criminal, when they're done, they can give their entire case over to the administrative investigators, and there's no conflicts there. So if the two are happening simultaneously, there has to be a firewall between the two investigations, which means there's no information sharing going back and forth. And one of the reasons is because of the criminal admissibility threshold for, again, the Garrity and Weingarten considerations. You don't want to muddy the waters and have a statement made by an employee that was compelled, meaning that they felt that they would be fired otherwise, and that make its way into the criminal investigation, because that can taint the entire criminal investigation and potentially allow for there to be no criminal charges filed later. So we'll talk about a little bit more what the IIT is. So it was established by the WAC, the Washington Administrative Code 139.12.030. That's what created these IITs. It defines what is an IIT and how that all works. But basically, they're comprised of multiple law enforcement agencies generally speaking, in the same geographic area. So a county sheriff's department, and then usually a lot of the municipalities that are within that county, and then maybe neighboring counties might all be part of that same IIT. There's a requirement to use a minimum of 2 non-law enforcement community members. So typically that's any volunteers from the community that have not been or are currently in law enforcement that have an interest on doing these types of investigations and sitting on these committees. During the investigation, they cannot share any information to the involved agency. They have to release information, basically provide a media release every week. The IIT community members get an advance copy, and if there's any surviving family members, they would also get the advance copy of that media release. The IITs require annual training both for the detectives and for the community members that are part of that IIT. And then there's also a requirement for the IIT lead detective to obtain and maintain a lead IIT certificate. And that's something that the Criminal Justice Training Commission, CJTC, they provide that credential. And there's a series of requirements like homicide basic, interview interrogation, and a patrol tactics course. You have to have all of those and be sponsored by the chief of your agency to obtain the lead IIT certificate. And then there's additional ongoing trainings that are required every year to maintain it. But an IIT is all of those things, and their sole responsibility is to investigate a deadly use of force incident, and then they review that for any potential criminal charges to the prosecutor's office, who would have jurisdiction for the incident. So separate from an IIT then is the Office of Independent Investigations. As I mentioned earlier, that's a new state agency created in 2021 by the legislature, signed into law by the governor, and it's interesting. The office is actually a direct report to Governor Inslee, and the director, the new director, is Roger Rogoff, formerly a judge in King County. But that office is going to investigate only deadly force incidents. And they're going to work with IITs. As I said earlier, right now they don't have investigators hired to a level where they could actually respond to any scenes. So they rely on IITs to do the investigation, basically hand off a complete investigation. They'll review it and see if they have any additional questions or any additional investigation things that they want. Otherwise, that is going to be basically a review of their case. And then if they do have any findings or concerns, they can file back with the prosecutor's office or with the attorney general's office. Their ultimate goal would be to work these cases without using an IIT, and that might happen, but is probably, again, years away because they have to staff up an entirely new state agency. And as I mentioned, they are able to review cases, and they also have the ability to review previous or closed cases. So if there's new criminal evidence that comes forward on a previous case, their office has the ability to reopen that case and then refer it to a prosecutor if they have any concerns. So shifting gears now, we understand, legally when force can be used, the gram factors, how those are applied, what's necessary and reasonable, and then who's going to investigate them. But how do they get reported? So it's interesting that across the United States, there hasn't ever been a standard system for reporting police uses of force until 2019. And in 2018, the FBI introduced a new voluntary process from which to collect information from law enforcement agencies. The FBI for a long time has been collecting uniform crime reporting, or UCRs, from, again, voluntary for agencies to provide to the FBI, but that's on crime stats. So how many arrests for, burglary and vehicle thefts and homicides, that's been collected for years, but that's been voluntary. Something that really is entirely new is collecting the use of force information from police officers and police agencies. So when we look at that, that only just started in 2019, and it is voluntary, you have to look at how many departments are actually providing information. And because it's voluntary, there's not any strong enforcement ability on what that information reporting looks like. It's not standardized, and you can choose to provide certain things but not others. So historically, there's not accurate use of force information, and every agency collects and reports that information differently. Knowing that that's an important caveat to look at before we start looking at any stats, we'll look at some numbers here and statistics. So about 21% of U.S. residents that are 16 or older have had contact with the police in 2020. So you're about a quarter or a fifth of everybody in the U.S. will have some sort of a contact with law enforcement in a given year. That was a little bit smaller than in 2018, where it was up to 24%, so almost a quarter. And part of that could be from COVID and a lot less travel and movement in 2020 than there was in 2018. You had 12%. Females were 12% more likely than males to initiate a contact, while males were 11% more likely than females to experience self-initiated or police-initiated contact. And then among U.S. residents who initiated their most recent contact with police, almost half did so to report a crime. So almost half of everybody who has police contact is doing so because they're reporting a crime. And you'll see there for the sworn law enforcement officers that are contributing information to the FBI. In 2020 it was 53, and 2021 it's up to 63%. But you're still looking at 47% of all law enforcement's not reporting their use of force information basically to date. And then when we look at use of force, 98% of all force is occurring at that officer presence and the officer dialogue, giving warnings and verbal commands. So it's very infrequent. You're talking, it's actually less than 2% of the time using any type of physical force. So we'll look at some more stats here. Almost 57% of officers involved in any kind of response were responding to a suspicious activities report. 11%, these are for force, stemmed from traffic stops. 10% resulted from a warrant, service, or court order. You can see the stats there for medical or mental health calls, follow-up, and then almost 7% were unknown and unlikely to ever be known on the type of call for why law enforcement is going to these types of scenes anyways. And again, this is 2021, where you do have COVID, so some of the numbers are maybe a little bit skewed because of COVID, but this is the most recent data that was available on hand. So, as I mentioned earlier, an average less than 2% of contacts of all law enforcement contacts result in the use of force. So there's more than 250 million contacts made by police each year. That's a big number of those contacts go without any level of force being used whatsoever. And when you look at that 2%, some of the data suggests that when deadly force was authorized, meaning they were presented with an opportunity where they would have been justified to use deadly force, 93% of that time, officers still use a lower level of force than deadly force. Which, so of those 2%, there's even more opportunities where officers could have been justified to use a lethal use of force and they choose a different tool or they're able to de-escalate it 93% of the time. So overall, and this is obviously a very difficult thing to try to estimate, but some publications estimate the odds of being involved in a deadly use of force situation with law enforcement is about 1 in 58,000, which is a 0.0172%. Again, I think that's very difficult to quantify. As we looked at before, right, the use of force continuum and the officer's thought processes and perceptions, it's hard to quantify because a lot of that is going to be driven solely by the way that the contact is going and the perceptions of the officer. So if there's active resistance or some movement that the officer perceives to present a deadly threat, obviously that's going to be something that would increase those odds. But conversely, being compliant and not resistive, listening to officer commands, would also reduce the ability or the likelihood of that becoming a lethal encounter, the same but opposite direction. So this week, the assignment, you're going to have the opportunity to review a real use of force that's captured off of a body-worn camera. And when we watch that in the module, we're going to apply the Graham factors, take a look at what necessary and legal requirements existed or didn't exist. That's going to be for you to decide and to write about. And then you'll have to determine whether or not the use of force and the uses of force, each one individually, were necessary or justified. And so it'll be really important and critical to have a good understanding, go through the module. There's I picked some videos I think that do a really good job of explaining the Graham factors, explaining the use of force continuum, that go beyond what I covered here today in the brief overview. But that will really help you get an opportunity to see how quickly an incident kind of evolves and how difficult later it can be to try to go back through and remember the types and the number of uses of force and evaluate if each type of force that was used is reasonable and justified. So I hope that you enjoy the module. Hope you get something out of it, and I will see you later in the week.